Oh,
Thank you so much, ladies and gentlemen. Welcome to the National Constitution Center. I am Jeffrey Rosen, the president and CEO of this wonderful institution, and it is so great to welcome you back to the keynote opening event of our blockbuster fall season. The National Constitution Center, as those of you who've been here before know, is the only institution in America chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis. And we are about to be transformed by the opening at the end of October of a new gallery displaying one of the 12 surviving original copies of the Bill of Rights. This is the first time that an original copy of the Bill of Rights is returning to Philadelphia in 200 years. It will be joined in a magnificent new gallery with rare copies of the Declaration of Independence and the Constitution, making us one of the only institutions in America to display these three documents of freedom in one place. And this will be the anchor for an incredible fall of debates and panels and symposia and podcasts about the Bill of Rights, and I hope that you will join us for all of them. I can't help plugging the ones that are coming up, including on September 17th, Constitution Day. Judges from the Third Circuit Court of Appeals will come to the Constitution Center to speak to school kids about what it's like to apply the Constitution in their courtrooms. We have an incredible debate with Intelligence Squared about the president's surveillance power to collect cell data information. We have book events on Abraham Lincoln and George Washington and John Marshall. We are giving the Liberty Medal to Malala, a symposium for federal judges on the legacy of James Madison. And then finally, on October 27th, the opening of the Bill of Rights Gallery, presided over by Justice Samuel Alito with Governor Jeb Bush. The gallery is being named after his dad, President George H.W. Bush, our beloved former chair, David Rubenstein, and members of the Philadelphia Opera and Orchestra. So it is going to be an incredible fall season, and I hope you will join us for all of that. I could not be more excited than to open this amazing panoply of discussions on the Bill of Rights with my friend and colleague and one of the most distinguished constitutional theorists in America, Richard Epstein. Richard's new book, The Classical Liberal Constitution, is the culmination of a distinguished career rethinking constitutional interpretation and making him one of the most original and distinctive constitutional voices of our time. And in our discussion this evening, we will discuss how Richard offers a powerful alternative to the conventional theories of constitutional interpretation, namely conservative originalism and progressive living constitutionalism. He calls it the classical liberal constitution, and it will be thrilling to examine the power of his ideas. We couldn't be better served in an interlocutor than my friend and neighbor, Ted Ruger. Ted is a professor of law and deputy dean at Penn Law School. He has written path-breaking work on the application of judicial authority. He has written about American legal institutions, and the Supreme Court have shaped the field of healthcare law over the past decades, a topic about which Richard writes as well, and therefore we are just going to have a great conversation. All right, Richard, we have so much to discuss. I'm going to jump right in by one of the most striking of your claims, which you make throughout the book, but in particular in the conclusion. You say the central message of the classical liberal constitution is to go against the grain of modern Supreme Court jurisprudence and much of the legal scholarship that's grown around that body of work. And you also say repeatedly that conservative originalists have moved too far in embracing judicial restraint. And you question the deference that conservative justices and theorists show to democratic legislatures and call for a measure of principled judicial activism. Tell us more about that.
Yeah, I mean, one of the things that you have to deal with in constitutional law is to sometimes accept the proposition that the obvious propositions are true. And when you look at various kinds of constitutional provisions, particularly those which are contained in the Bill of Rights, many of them are drafted in very broad terms. Congress shall make no law abridging the freedom of speech, nor shall private property be taken for public use without just compensation. Now, the only way in which you can understand words like freedom and private property is to be able to figure out how they are used both as a matter of political theory and as a matter of common law, that is general judicial interpretation. And private property, for example, is an all-embracing notion. So to say that you believe in the fidelity to text and that you believe in narrow interpretation essentially puts two ideas into tension with one another. You're not loyal to text on the one hand if you read it narrowly when the text is broad. And so what you have to do is to figure out what it is that you do in order to keep the broad readings faithful. This creates a real problem in constitutional interpretation, because one of the things that are wrong with the originalism, particularly that associated with Justice Scalia, is that often he thinks that the Constitution text is self-contained. But in fact, going back to Roman times, and I should tell you, one of my deep areas of academic involvement for over 40 years is I'm perhaps the last living American Roman law professor who teaches this subject full-time, is that the Roman interpretation strategies took provisions like this, and they said, you know, we realize that they're not self-contained, that if we have a prohibition against taking private property, well, we better have a prohibition against blowing it up, even though we may not take the pieces, and that leads to the law of inverse condemnation. It means you can never take private property, even when somebody has a gun at your head, you can't disarm them. Or you can take private property, how do you measure compensation when it's supposed to be just? So there's this whole elaborate body of non-textual stuff that has to be read in, and that stuff essentially goes traditionally under the name of the police power, narrowly understood, where every major constitutional prohibition is subject to exceptions for health, safety, morals, and general welfare under the traditional formulation. And you have to explicate all of those terms as well. So the project becomes extremely hard. There's one further difficulty I'll mention and then take on after this. Is unfortunately, interpretation is a human activity. Many times it's done by people who don't quite get it right. And what you then have to do is, if you go on the first wrong step, you keep going down that path, or do you try to correct it? And in many cases, the thing to do is to essentially ratify earlier errors on the grounds that they've helped the Constitution survive as an active political entity. So to give you just two illustrations, the general rules on judicial review, that is, can the Supreme Court overrule statutes of Congress, and general review on judicial review over the states, it seems pretty clear if you're a close textualist, it could do neither of those two things. We could not run America that way. So in addition to being able to go beyond the text in a static sense, you also have to be able to incorporate what I call the prescriptive Constitution. That is, those changes that have become so ingrained in the American fabric that it becomes impossible to get rid of them. Just the way when you look at land law, there's a theory of prescription or adverse possession, which says that repeated trespasses stop things that are wrongs and turn them into rights.
Okay, so Richard has said a bunch of important things, namely that the conservatives are wrong to be pure textualists. The text doesn't answer all the questions. Mm-hmm. Justice Scalia says Richard is wrong to be a pure originalist because you can't ask only what the original people thought. And he also says liberals are wrong to be progressives and to try to read in all of these new welfare rights that are bad for the country and not justified by the Constitution. So is he offering basically a political theory? He believes that classical liberalism embodied by John Locke and Montesquieu and John Stuart Mill is the right answer, and he wants to read that theory into the Constitution? And do you agree that that's the right thing to do?
Well, I would just say to your two questions, yes and no. In other words, and I should say I'm very happy to be here. I do love the book. It's worth reading. It's provocative. I agree with much of it, but I do disagree with some things. I applaud Richard's, I think, totally well-founded critique of a kind of precious original intent or original meaning originalism that is become, I think, more prevalent in the Constitutional Law Academy, even in the dozen or so years that I've been teaching. There's kind of been a renaissance of this kind of thinking, and I think it's wrong-headed very much for the reasons Richard stated about trying to fix with precision some these vague words that, intentionally vague words, I should say, that the drafters of the Constitution used. I also think that, and applaud Richard's candor at bringing in this very clear, prescriptive, unifying vision of classical liberalism. And I think he lays his cards on the table. It's a powerful vision. And it's a vision which I think, even as somebody who considers himself a progressive constitutionalist, I agree with many parts of this kind of liberty-protecting vision. So this leads me to a few somewhat inconsistent quibbles with, or more than quibbles with the book. And here I'm reminded of, there's an old parable we teach in law school about kind of incoherent critiques or incoherent arguments, which is the story about the borrowed kettle. And it goes something like this. My neighbor comes to me and says, look, you borrowed my tea kettle and see this crack in the handle. You did that. You gave it back to me with the crack. And I say, no, I didn't, and I've got 3 reasons. First, when I borrowed the kettle from you, it had the crack in it. Second, when I gave it back to you, it was in perfect condition. And third, what tea kettle? I've never borrowed that. I've never seen that. This is kind of my approach to the book in the sense that I think, on the one hand, I want to say that the fundamental starting point about the constitutional framing in 1787, which happened just a few blocks south of here, is overstated and kind of one-sided in Richard's telling. It's important to remember that we're not, and we do know, we're not meeting in York, Pennsylvania. And why aren't we meeting in York? We can be happy we're meeting in Philadelphia. Well, York is where the Articles of Confederation were framed and drafted. They didn't work, which is why the framers came back to Philadelphia in 1787. And if you read Madison and Hamilton, quite consciously wanted to draft a stronger document with a stronger national government. And Madison in Federalist 51 famously says, this is a very difficult, he says, this is the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. He, and I think the other framers recognized this compromise and the duality too. And Hamilton wrote about empowering the national government with force and vigor. And I think Richard's book emphasizes the latter concern, which was very valid, remains valid, about making sure the government controls itself, and de-emphasizes too much the notion that we needed to come back to Philadelphia to have a national government that actually did have some force. Just more quickly, I don't want to, I'd rather hear Richard, but my other kind of inconsistent reactions are that Richard's framing here is right historically. You can make a good argument that the original Constitution and the kind of first century or more did embody kind of classic libertarian values, but that we fundamentally changed as a country in the 20th century in ways that it is entirely appropriate to adopt and embody in our constitutional tradition. That the myriad ways in which our society and culture are different today than they were over 200 years ago is actually an acceptable form that we can rethink and revise our fundamental constitutional understanding of the role of government. Yep. And we do have, along with that, as most of you know, we do have the hardest constitution to amend in the world vis-a-vis its text, which means that constitutional change often has to happen outside the text. And so I think if we do have a constitutional vision today that's different from the original classical liberal constitution, I think that's entirely appropriate and indeed is the pathway of constitutional change that the framers who wrote We the People might have envisioned. Finally, and we can return to this perhaps, we were talking about it before a bit, is we all share certain kind of liberty-protecting and libertarian impulses. And in that extent, I kind of agree with virtually everything Richard says in the book about the importance of our founding document protecting that. Where I come out differently is that I think if viewing liberty broadly construed to include not merely economic liberty, but also religious belief, reproductive freedom, marital choices, a host of other things, we may be at really a high watermark of liberty viewed over a 200-year cycle, not a kind of declining asset, as Richard's book suggests. So
Richard, I want you to respond to Ted's powerful critique. He says, first of all, the framers took a more expansive vision of national power than you suggest, and also the government has expanded so much, and that's a good thing, that your classical liberal constitution would require striking down much of what the government actually does today. What precisely would have to go if your vision were adopted?
Well, first of all, let me explain what the vision is and tell you what stays and what goes. And I think there is some confusions in what Ted said that I'd like to try to correct. First of all, the phrase that I used was that whenever you looked at a text, You had to figure out the various embellishments of it, the circumvention problem, justifications, choice of remedies that are not there. I did not say the text was vague, and I don't think that it is vague. The word private property does not mean exclusive possession. The word private property has always meant exclusive possession plus use plus the powers of disposition, and that's a pretty clear meaning. The word commerce, particularly when used in the Constitution, has never meant manufacture or agriculture. It has only meant trade of goods and the shipments of passengers across the line. And when you start to read these things as vague, what you do is you now can basically narrow the definition of property, which gives government much too much power to shift wealth back and forth through politics. And you can expand the scope of the federal government, which is disastrous because it allows you to create nationwide cartels. The second point, which relates to the first, is these concerns are not concerns that disappear as you move into the 20th century. Adam Smith essentially wrote a treatise saying about the dangers of mercantilism, and it turns out that those kinds of dangers apply every bit as much today as they did then. There is nothing about the antitrust laws which treats cartels as a per se violation, which has changed over 200 years. And what the expanded reading of the Commerce Clause has done is to always create a situation now in which agriculture, labor, motor vehicle, the whole system of cartels is there. And the great rap against progressivism is a cartel manufacturing machine, which has never been defensible and cannot be defensible. Changed circumstances don't alter this. Today, transportation and communication are better than they've ever been. There's actually less need for national regulation than there was in 1789 because the movement of goods in and out across state boundary lines is what disciplines local monopolies. And so the original conception that Congress could keep the arteries of transportation and communications open and doesn't do anything else is actually more powerful today than it was in 1787 when you had these geographical monopolies. Ted referred to the situation associated with the Articles of Confederation. He's right, but it's understand what the remedies were for the difficulties that they were trying to address. The Articles of Confederation did not have a president. Well, as last I did, I looked at the Constitution. It says we have a president, and we don't have two. That much, I think, is at least clear, although sometimes we might wish that we could have a substitute here and there. It turns out that we had no central judicial power. Well, it turns out now we've got a central judicial power. It also turns out that we did not have the power to essentially tax or to raise money by debt. You look at Article 1, it says, the Congress shall have the power to tax, and the power to tax shall be used to pay the debt, to provide for the common defense, and to provide for the general welfare of the United States. This is much broader than no power at all, but the recent decision, starting in 1937, which read this as an unlimited broad power, embraced by both the liberals and conservatives, is just plain wrong historically. Paying the debt means paying public debt, and you have to do that in order to finance things. Common defense is obviously the standard public good. Either you fund it collectively or it will fail. And the general welfare of the United States did not mean the welfare of individual citizens. It meant essentially the collective welfare of the nation, so that the whole point of this provision was to say that the Congress could not take transfer payments from one individual to another, which essentially create factional struggles that can blow, as it has blown, the United States apart. Now you're saying, well, where do you get this from? Well, A, it comes from the text, and B, every single consistent interpretation of the Constitution through about 1920 took exactly this point of view, that factional struggles could be limited only by putting real tight limits on the taxing power. So now, do we have a changed world? We do. But it turns out that none of the peculiar New Deal reforms, which expand federal power or weaken property rights, in fact, get you to a better place than you would otherwise be. That is what I want to sort of make very clear, is when I sort of tie this back to classical liberal theory, the textual supports are clearly there. I don't think anybody would want to deny that. Enumerated powers, limited taxing power, all the rest of that stuff. But I'm also saying that the theory that animated it is a theory of perpetual validity. It's not one that comes and goes with fashion. And the indeterminacy that you have from political conflict, the short-term taxes, the special taxes, all of those things, essentially what they do is they secure the gains to what Madison called factions. That is, special groups whose private interest is against the public interest writ large. And I want to make it very clear, classical liberalism is not a theory that the individual is glorified to the extent that he deviates from the world at large. It's a theory which says you want to so structure human institutions so that whenever anybody acts within the rules as we set them up, the only way in which he can prove himself is to improve the overall level of social welfare. So there is a direct connection between classical liberalism and modern social welfare theory. There is no connection between modern progressivism, which drives you to monopoly, which is the absolute antithesis of that theory.
Ted, much of Richard's response focused on the Commerce Clause and the limits of Congress's power, and the most controversial parts of his theory have been the claim that if it were applied, then much of the post-New Deal administrative state would be struck down. Mm-hmm. And Richard, in his book, says that only Justice Thomas on the current Supreme Court really embraces his limited view of the Commerce Clause and criticizes the other conservatives for not doing so. What would happen, first of all, if Richard's view were adopted? And tell us about the Affordable Care Act case, which you've written a lot about, and in which all 5 conservative justices did adopt a pretty limited view of the Commerce Clause. Was it an Epstein-like view, or did they come short of everything that Richard hoped for?
Well, so I'll answer the last question first. I actually think it's a testament to Richard's, one could view, and when we write the history of the Affordable Care Act cases now and the Commerce Clause jurisprudence of our era, we, I think, can discern Richard Epstein's influence in what I view as a new Commerce Clause rule, a reduction of the scope of the Commerce Clause. Now, you also asked, is this Richard's vision, or is this what Richard wanted? I would let you speak, but I think the answer is no. They didn't go near far enough, okay? They made a kind of, in my view, as you may know, they said that the individual mandate, which would have made people pay a penalty, which does make people pay a tax penalty if they don't prove insurance, could not be justified under the Commerce Clause because, according to John Roberts, who wrote for the majority, this would compel somebody to act, and thus it regulated inaction as opposed to action. And so they kind of kept all the post-New Deal 20th century Commerce Clause doctrine on the books, but added a new requirement that the government can only regulate action, not inaction. And I do think the ferment over restraining national authority that Richard and others have provided intellectual heft to was important for the 5 majority justices there. Now, I guess one thought I've often had, and that I think is understated, Richard, in your book, is the notion of kind of political restraints on government power. You cast the government as rapacious and relentless in its desire to regulate and over-regulate, and indeed, sometimes it is. But let's take an example from the healthcare case, which dealt with something some of us love, some of us hated, broccoli, okay? And the claim was often made that if the government can force you to buy insurance, it could force you to buy broccoli, maybe even eat broccoli, which was viewed as heavy-duty rhetorical ammunition. And that was indeed that came up in oral argument. And we know, I guess, after the Supreme Court opinion, that the federal government, Congress, cannot force you to eat broccoli now or buy it. But there are 50 governments, more if you count DC, right now that could enact broccoli mandates. And it would save them Medicaid costs. It would improve the health of their population. Lots of science. It would maybe even pass a rational basis test. We have zero broccoli. I mean, and I'm talking, of course, about state governments, which are not restrained by Commerce Clause restrictions. We don't have broccoli mandates or anything like it. And I think we have to ask ourselves, if we have this conception of a government which will always regulate to the maximum of its constitutional power, why don't we have any broccoli mandates? And I think the answer is in our bicameral separation of powers, in our two-party system, and in the natural ability of Americans imperfectly to influence their legislators and say, stop, you're going too far with these regulations.
Yeah, now,
why don't we have broccoli mandates, and would they be unconstitutional if the states passed them?
That's the whole point. One of the things I want to make very clear is I thought the argument about broccoli was one of the dumbest sets of arguments that had ever been advanced in the history of Western civilization. And let me see if I can give you a slightly better argument to explain why I'm concerned with overreach. The key decision that drove the Commerce Clause analysis was a case called Wickard and Filburn, decided in 1942, in which it was said that the United States' power to regulate commerce amongst the states included the ability of the Congress to regulate the amount of grain that a farmer could feed to his own cows. and even though nothing moved in interstate commerce. Now, if you just do this as a textual matter, I can remember what my wife said when I told her this in the car. She says, will you stop teasing me? I am not that stupid to believe that this means that. But of course, what she didn't understand, and which I did not explain to her at the time, is there was a perfectly sensible reason for the new dealers why they had to do this. What happened was they wanted to keep the prices of grain high. So what they did is they said, well, you can't sell it in interstate commerce. So people turned around and they sold it in domestic commerce, that is within the state. Well, that killed the cartel. So what they then did is they say you can't do it that way. What they then did, in effect, is they integrated. That is, the farmers bought the cow field so that they didn't have to sell anything. And Wickett and Filburn was an effort to make sure that 20% of the grain consumed in the United States could be subject to government regulation. And so it's not a stupid thing for them to want to do. But if you want to find one program which you want to immediately terminate, it would be agricultural subsidies of the worst sort. Ted, I think, agrees with that. Inexcusable. And what Wickett and Filburn did, because of the elegant pen of Justice Jackson, was that he allowed these things to go forward. And so that's what keeps Obamacare alive. And what I wanted to do was to get rid of Wickett and Filburn. I thought all the filigrees and all the little bits and pieces made no sense. Now, the question is Congress always rapacious? No, of course it's not always rapacious. One of the sad things is I can tell you many good statutes would get struck down when people don't understand why they are put into place. And, so it's not that. It's just that you want to get rid of the cartel facilitation that takes place when you're doing this. Now, Justice Roberts' opinion is just an intellectual blunder of the first order. Now, why? Not because he gets the Commerce Clause wrong, which he does, but the key thing to understand about the earlier precedents, including cases that he cited, were that you could not use the Commerce Clause where you can't use the taxing power, and you couldn't use the taxing power where you didn't use the Commerce Clause. That is, it's a legal doctrine called these two things are in pari materia. That's a wonderful phrase, meaning basically they're the same stuff. And it turns out that if you go back and you look at these various type situations, if you now decide that you cannot regulate this thing under the Commerce Clause, then the tax clause has to follow with it. Now, this was developed 100 years ago, actually 90 years ago, in something called the child labor tax cases. And in the pre-New Deal Constitution, what had happened was in 1918, the Supreme Court, in a key case called Hammer and Degenhardt, struck down a statute which said you could not ship in interstate commerce any goods made by any factory which at any point in its operation had violated a child labor law that the federal government had put together. And Justice Day, one of the smarter conservatives, said this is tantamount to a direct regulation of local production, which was illegal at the time, and I'm not going to tolerate it. And he was right about that, because you gain a few dollars from using child labor, but you lose a fortune if you can't sell your goods into national markets. And so the coercive effect of this was very apparent. Well, 3 years later, Congress never quits. This is bad Congress. So what they do is they put a prohibitive tax on the same goods. And now you can't sell them into the state commerce because the tax will kill you. And what they did is they struck that down on the grounds that the two things were in parallel. Now, you may expand the Commerce Clause after 1937, but you never got rid of the parallelism. And Justice Roberts missed that fundamental structure, because you never want to have a situation when two things which are close substitutes, direct regulation and taxation, are subject to different legal regimes. And the earlier guys got that right, and if he had gotten that right, he would have had to come out the opposite way. It may sound like a technical point, but it's very different from broccoli, as far as I'm concerned. And in fact, the worst enemy of a good classical liberal theory is some kind of ingenious conservative argument which starts taking these silly examples and treating them as though they have structural significance.
All right, Ted, so Richard was not shy, as you predicted, about telling us what he thought about Chief Justice Roberts' opinion, but I want to drill down on exactly what the consequences of his theory would be. And he's not shy in the book at describing it either. He suggests that a proper application of the classical liberal constitution might call into question much of the post-New Deal administrative state, including health and safety laws, environmental laws, other administrative agencies. Spell out what you believe the consequences of the theory would be. What would have to be struck down, and then we'll let Richard respond.
Well, I think you've kind of pointed to the way there, Jeff, which is that The vast majority of federal agencies that regulate public health, safety, traffic conditions, et cetera, are based on this, I should say traffic, airlines perhaps.
Be careful,
would be
yes.
yeah, that would be, I think we could be, Richard and I would agree that those, we save those, right?
The TSA is okay.
But I'm thinking of the EPA would be gone.
No, complicated.
Okay, well, I want to hear what would be left of the EPA. The agencies like OSHA and kind of workplace safety agencies, probably the NLRB is gone. But what's interesting, I'm dodging your question. The NLRB, I mean, labor is almost gone even without the constitutional. I mean, union rates in the workforce are at almost an all-time, or I should say a 40 or 50-year low without constitutional change. So your claim about cartels in that context, I think, is overstated.
No.
Lots of these agricultural price regulations, I think, would be gone. And I'm certainly not here to defend the wisdom of our agricultural policy, although I think I will defend the constitutionality of those things. Interestingly, and I guess this is a question, I'll make an assertion, but I'm not sure, Richard, you would say that major programs like Medicare and Social Security, the kind of tax and spend programs, are those still okay? I think those are not typically justified on the commerce power.
No, but they don't meet the taxing standard that I set out.
So okay. So I think some people who subscribe to your views on the Commerce Clause would save Medicare and Social Security just under the tax and spend power.
But let me sort of answer this in the following way. It's one thing to deal with these things when they've been established and in place now for 50 years, and you're trying to uproot them, where I think it's extremely dangerous that you do so. And when I talked about this in my takings book, for example, some 30 years ago, I said you just can't do these things because retroactivity, vested practical rights are extremely important. And so whenever you want to upend a program, you can't do it in a set of circumstances where there are lots of people. If you're struck down Medicare, who are 83 years of age, no alternative source of income, you're saying, bye-bye, we made a giant mistake. So the problem about the transformation is very different from the question of what the original validation of these programs were. And one of the reasons why, for example, with Obamacare, I would want to fight so hard is this thing will turn out, as it's turning out, to be something of a systematic calamity. But once you get in there, then the retroactivity, reliance, interest, settled expectations all comes and makes it much more difficult for people like myself to come forward. So you have to understand that this is not a program for short-term political action. It's basically an effort when you introduce these programs the first time to see whether or not you need them. And if you never had Medicare, well, what would the world start to look like? Is, I think, a fair question. Well, it would look very different. There might be some state programs which would be constitutional under these purposes. I don't think they would last all that well because of the movement of people back and forth across state lines. But things like the Indiana program, which is on healthy care, which is far better than the federal statutes, might well survive. And I'm not trying to fight all of those things off. But the key feature is that what you would see is a much richer development of private programs that do exactly this problem. To give you the historical situation, 1935, you look at life expectancy, all of a sudden retirement is a real thing because people are beginning to live in their 60s. Life expectancy, 1947. Life expectancy, 1930, 61, right? I mean, it starts to make it. So companies like General Motors say, we better start having retirement packages for our employees. Moment Social Security comes in, these packages are all basically made supplemental or they disappear. And so the key feature is you're edging out the things that would have done a better job, would not have created the kind of systematic public debt that you have, and would not have this terrible problem that you can't reverse them. So with Social Security, just to raise the age by 1 year, which might even bring the system back into power, is something which is beyond the collective consciousness of Congress to be able to do. So we put these things into place and we can't write them because the vested interests of various groups are so strong. So it's a very different world. Now, take the labor case. I think Ted is clearly wrong, and let me explain to you 2, maybe 3 reasons why. First of all, the number of people who are in public unions is quite large. It's 40%. And, I've looked at some of these pension programs and they're prescriptions for disaster. They're not exclusively a union problem, but they're heavily a union problem. And you could bankrupt Illinois, you could bankrupt half of California cities like San Jose and so forth. This is all labor stuff, because it's now perfectly okay for state legislatures, not in my world, to create essentially mandatory card check authorizations for public unions to beat up the government. Of course, they're non-budget, off-budget devices that get that way. Private unions, yeah, they're only 6% of the people, but they cover a lot of firms. And what else do they do? Well, they make sure that you're not going to get a Walmart coming into New York City because the union opposition will be there. They will try and do everything they stop to stop imports of cheap goods which go into competition for the American services and so forth. And the real danger of unions today is not, in my view, in the way in which they operate at the bargaining table. There are no monopoly rents for them to capture, so the strike alternative, I think we both agree, is way down. It's what they do in the political arena, both domestically and in terms of their foreign affairs. That seems to me to be the serious sort of issue. Now, what else would go and what would say? Let me just make the following remark. The government wants to regulate safety on interstate railroads. There's not the slightest bit of problem with that, unless there's some individual gaming around it, which is not a serious issue. If you want to do it on local bus companies, you can't do it under my theory. In fact, one of the things I urge you to do, and this goes to the vagueness point, is look at every transportation carrier you can name and tell me whether you think there's any difficulty in describing whether it's an interstate carrier or a local carrier. There's basically no cases that give you any serious problem on that particular stuff. But other things, I mean, National Labor Relations Act, it would disappear from manufacturing. What about state stuff? Now, Ted mentioned something that 50 states could regulate. And he's certainly right about it because you don't have the Commerce Clause problem, right? But there is the following interesting feature. There is a clause in the 14th Amendment having to do with privileges or immunities. And so the way the 14th Amendment is structured, the first clause of it essentially gives citizenship to everybody born in the United States. And this has a modest rule of overruling Dred Scott. So all native-born slaves are now citizens. Huge accomplishment in and of itself. The next provision says, for all citizens, the state shall neither make nor enforce any law that abridges the privileges or immunities of the citizens of the several states or the United States. This was meant to be a huge limitation on what states could do. And it got read out of the Constitution in 1872 in the Slaughterhouse case. I think those restrictions still ought to apply. And it's the right system. What happens is the states get to experiment. But if they start to engage in confiscatory legislation, there's a federal, if they start to engage in confiscatory legislation, then there's a federal check. And that eventually took place through the Takings Clause and incorporation. So you get a smaller government, but it's a smarter government. And in the end, by using the local powers on these local issues, the key constraint, and I'll just end on this point, is that competition between states on tax levels and on regulatory levels is, in fact, a very powerful political check, because when corporations and individuals decide where to locate, look at the map right now. States with right-to-work laws get net immigration. States without them lose it. That's just a classic illustration of how this competitive federalism can work.
All right, Richard said a lot, and we're obviously we're going through a lot of material here, but Ted, one of the things he said is that you're right. If the states passed 50 you have to eat broccoli laws, that would violate the Privileges or Immunities Clause of the Constitution. In making this argument, he is calling into question the tradition that conservatives embraced for much of the 20th century, which is that it was bad when the Supreme Court struck down economic legislation. And Richard ends his book by sharply criticizing a progressive hero, Justice Oliver Wendell Holmes, and the most famous dissent of the 20th century, which occurred in the Lochner case. The Lochner case, as you lawyers know, involved the court striking down maximum hour laws for bakers. And Justice Holmes famously dissented and said the Constitution
did not enact Mr.
Herbert Spencer's social statics. Good, you can do it by heart. Very good. We'll do the next sentence too, which you criticize further. Is not intended to embody a particular organic
relationship of the individual to the organic relationship. You say.
Good. No, I can read it. It's right here.
Yeah. Oh.
You say he committed a constitutional blunder of epic proportions when he claims that a constitution is not intended to embody a particular economic theory. You say no constitution could hope to survive if it's not driven by some general guiding theory. This is heresy for progressives. Everything that we were taught in law school, that Lochner is evil. Richard is questioning. No fewer than most of the conservative justices, John Roberts, Samuel Alito, and Antonin Scalia, have all equated Lochner with Roe versus Wade, which they don't like. How radical is this suggestion to try to resurrect this case, the Lochner case, and to get courts back in the business of second-guessing economic legislation?
Oh, I think it's doubly radical because it's radical prescriptively and intellectually, and Richard has very artfully explained its radicalness. But it's also radical institutionally in the increase in the fact that it would radically increase judges' power over our lives and judges' power to micromanage and retroactively scrutinize legislation. So you can read the Holmes quote two ways. One as a rejection of a certain laissez-faire, or as I think Richard says, a kind of cartoonish laissez-faire ideology read into things. But you can also read Holmes's, this in connection with some of Holmes's other writings, as a rejection of judges scrutinizing laws using judges' own substantive values and holding a lens up. So this book does a masterful job of holding specific cases up to this very masterful general theory that Richard offers. But you can't judge all the cases, Richard. So it's actually, this is both a critique and a question, and in the sense that, are you comfortable with federal judges who are appointed through a political process kind of scrutinizing, or state judges, scrutinizing each piece of legislation to see whether it meets your conception of the social benefit?
Well,
how are they going to do that?
Well, it turns out we do that anyhow. And one of the things one has to do is, let me mention, before I talk about Lochner, there's another famous Holmes dissent, the dissent in Abrams, where he starts to talk about the need to allow people to speak, and the First Amendment protects them from government regulation unless there's a clear and present danger in the way it goes, because it turns out that the best test of an idea's truth is its ability to get itself accepted in the marketplace of ideas. Straight kind of laissez-faire theory. Anybody who looks at the First Amendment cases now will realize that these guys, when they look at individual cases, they slice the salami very thin. The burden of proof on truth in a defamation case is now a matter of constitutional interpretation, for example. When you have a statute which says it's inappropriate to impersonate some kind of a war hero, what the Supreme Court will do is strike it down because of its own empirical estimation of how effective the fraud is and whether or not you have to have a demonstrable injury as a constitutional matter. Now, my objection to those cases is not that they do the scrutiny, but they don't do it right. And now, why don't they do it right? Because they don't have a theory. And essentially, for the classical liberal, the theory is we know what counts as the standard wrongs, and we could set the ends, and then we could choose the means to minimize error. The ends are force, fraud, and monopoly, and then minor things which are not federal government, like dealing with infancy and insanity and guardianship and so forth. If you keep yourself to the right ends, you're not going to make mistakes. Then on the mean side, what you say is, look, we're worried about overextension or underextension of the rules, two kinds of errors. When the Supreme Court does strict scrutiny in the speech cases, that's exactly what it's doing. They're figuring, does this go too far? Does it not go far enough? So we already do this kind of stuff. Now when you come back to Lochner, why is it that the Holmes opinion is silly? Because you have here an opinion which says, you're talking about the protection of life, liberty, or property. And Holmes's definition of liberty in this thing is so narrow that it only means essentially the ability to escape imprisonment and beating up. So liberty of speech, liberty of contract, liberty of conscience, liberty of thought are not part of the Holmesian universe. That is simply nuts as a matter of constitutional interpretation. And he himself abandons it later on. So he's reading the term extremely narrow. Then he gets the arguments wrong. He says, well, this is just a shibboleth that you're doing. But remember what the context was. Lochner was a statute which was supported by union workers who wanted to keep alien workers for a German plan, Mr. Lochner, out of the marketplace. Now, the German workers, they work 16-hour days, and it sounds terrible. You read the statute, you see Section 9, which is upheld, not Section 10. It says that you have to have ventilation on sleeping quarters. That should tip you off that something's going on here. And the reason these guys work 16 hours is they worked 4 hours, slept 8, and worked 4. Maybe it was 5, 7, and 5. But they were sleeping on the job, and that counted as work time. The union workers essentially worked two separate shifts with two separate groups of men. And with Justice Peckham, who was on this issue, right, and sound, by the way, a real hawk on antitrust law, so the guy is no patsy. He looks at the situation and he says, all this is designed to do is not to protect the health of these workers. None of them are complaining. This is a criminal prosecution, for heaven's sake. It's designed to protect union workers from non-union competitors. That's what he said. Now, who agreed with him? Well, the New York Times. Not the New York Times of 2014, but of 1905, which says this is a victory for free labor over union labor. And they understood perfectly what's going on. So if you put this in a public choice kind of format, it's pretty clear this is not the standard kind of safety rule, like would say total amount of emissions of toxic stuffs inside the workplace. And indeed, every single justice who voted on Lochner to strike it down supported workmen's compensation laws, which were designed to deal with the other side. So they did draw principled lines. And what happens is the modern critics of Lochner, they kind of come along and they're like Felix Frankfurter, who understood nothing about the dynamics of labor. And he was such a passionate defender of collective bargaining arrangements, monopolistic though they were, that he thought that the line between health on the one hand and labor regulations dealing with competition on the other wasn't worth drawing. But he never answered the question as to whether or not people can actually draw. And he was wrong on that because the cartel formation that you get through unions and its distortions when protected by the states become enormous. And the old Lochner stuff, Peckham, 10 years before, upheld very aggressive enforcement of the antitrust laws against various kinds of cartels. I mean, the guy was essentially consistent. He used the antitrust laws to control them. He wouldn't let the states put them in place. And then when it came to the issue of rate regulation on monopolies, the 19th century judges were much more accurate on how this was to be done than the 20th century judges. I mean, they knew what the cross-subsidy games were and everything else. So it's not a question of could they do it in this hypothetical way. They did do it. It's throwing away an inheritance that actually worked. And so the growth levels that you have in the first third of the 19th century are just unmatched by anything that happened since. And it's all because of Franklin Roosevelt's New Deal and a bunch of judges like Felix Frankfurter who don't know what is a source of political intrigue and what is a source of production. It's amazing the level of ignorance that were brought to these things by a group of progressives who found all sorts of excuses for cartelization and always overlooked their dominant anti-productive effects.
Okay, we have some phenomenal questions from our incredible NCC audience, but I want Ted to respond to the extremely interesting note on which Richard ended, which is this is not only a constitutional argument, it's a policy argument. He said these progressive policies that the courts have been upholding are terrible for the country. And he ends his book by saying the motivation for this argument should be apparent from the disarray that infects every area of American life, decline in the standard of living, constant battles over the debt and fiscal cliffs, uncertainty over the tax structure. Basically saying these courts have to save the country from this catastrophe. Richard had a very notable debate with Justice Scalia, I think in the 1980s, that Cato debate. 84. So Scalia gets up and defends the traditional conservative position of judicial restraint and said courts should defer to democratic legislatures because if they don't, they'll be doing that stuff that we used to criticize liberals for doing in the 1960s, imposing their own policy preferences on the nation. And Richard tears away his prepared speech and says that's absolutely wrong, that conservatives have to abandon their allegiance to judicial restraint and unapologetically embrace activism. And then he just told us really what you need is not just the text or the history, but a big theory, and his is classical liberalism. In this sense, is he the mirror image of those liberal philosophers and activists who conservatives have long criticized, from Ronald Dworkin to Chief Justice Earl Warren?
So I commend the theoretical coherence and vision, and which is often lacking in constitutional argument. I do think it does make me think about Dworkin, who, Ronald Dworkin is somebody who's famous for the phrase judge as Hercules, or the so-called robust Herculean jurisprudence. And Richard, I think you're asking for a similarly Herculean task for our judges to kind of scrutinize every law against this theory.
I regard Dworkin as a piker.
I'm not saying you agree with him. I'm saying your view, your model is resonant with this.
No, in the following sense. he believes in Hercules. I believe in Hercules squared. And let me see if I can explain what the
So you're going
difference is.
further than Dworkin.
Well,
Yes,
because Ronald Dworkin, gifted as he was, essentially had only a single theme dealing with equal concern and respect, which he thought translated into various kinds of positive rights. He did not have a systematic theory of the Commerce Clause, separation of powers, all the other things, so that what happened, his domain was theoretically rich, but it was confined. Mine has no such constraints. It's a theory of the world.
But I think
it may
you're
be
alike
wrong,
in-
but it's more ambitious than the Dworkin theory.
Okay, but I think you're alike in that you and Dworkin both would put us in a government by judiciary.
No, absolutely not. And let me explain why, just very briefly, as to what the distribution of authority be. Let's start with respect to taxation. There's no question I have very strong views on what is permissible. But I think the government can set a court. General revenue taxes have to be flat. I'm violently opposed to indeterminate progressive taxes. But it's no business of the court to determine what that flat level should be. No business of the courts to determine what the revenue levels are. Those are all very powerful political decisions. Now, why do I care so much about this? The illustration I mentioned to Ted before we came in here was the medical device taxes that were put in as part of Obamacare. I think all special taxes on particular goods are just asking for trouble. And that one is about to decimate an industry. And the reason you want to do it through a general tax is if you can't raise it with popular support, it's very strong evidence the people themselves don't want it. If you can dump liabilities on your enemies, in this case it was the pharmaceutical folks who put it on the device manufacturers, what happened historically, that's an open invitation to disaster. So it's political. Now, the question about user fees, same thing. Let's get to environmental regulation as a global kind of problem, interstate pollution and so forth. I agree it is something for which it's kind of tricky to figure out how to do constitutionally because it was never an issue that was worried about in there. But my view is, you can have the government set the affluent standards for any pollutant that you want to make. But what it cannot do is pick which pollutants are going to be troubled and which ones are not. It means that the current structure of the Air Pollution Act completely unconstitutional, but it's also proved to be a complete disaster. If you had a rule which says, you figure out how serious pollution is, tax every unit of pollution the same way, you would get rid of the political intrigue and you would keep the environmental protection. And so take patent law. You can set a patent for a limited term. Doesn't tell you what the term ought to be, doesn't tell you whether you have a good faith exception and so forth. So you can go through all of this stuff. And what happens is the judiciary, through the classical liberal constitution, imposes a single dominant constraint which is designed to control faction, and therefore direct the power of the state to control real substantive ills that really need direction. And every single, this is, as I said, a theory of everything. One of the things I should tell you, I don't teach constitutional law. Most people kind of don't sort of know that. But I do teach all these other fields, environmental law, antitrust law, federal food and drug regulation law. And when I see the shipwrecks that emerge in these particular areas, by your standards of social welfare, and then I look back, it's the weak system of jurisdictional controls and property rights which essentially gives sway to these kinds of factional influences.
Okay, I want to run through these great questions. So Richard's answer is, yes, a strong judicial role, but not an overweening one. He does say that classical liberalism defends judicial supremacy, but there are plenty of examples in the book where he deviates from conservative orthodoxy, including your powerful criticisms of the Supreme Court's opinions on the Second Amendment, which you say misunderstand the fact that the Second Amendment, you say he's wrong. The central purpose is to prevent the federal government from dictating gun control laws to the states, and therefore it doesn't even apply in the District of Columbia. But I want to go through these really great questions. Our town hall audience is so smart that we want to get through as many of these as possible. So here we go. Who's your favorite or model Supreme Court justice?
I will mention somebody. If you've heard of this man, raise your hand, and I suspect nobody will. A man named Marlon Pitney.
Well, heard of him, but tell us why.
He was the most consistent classical liberal Supreme Court justice. What are his great achievements and so forth? Well, for one thing, he sort of understood the logic of freedom of contract in a way that Holmes and others did not. He understood that it was a mutual gain proposition. He understood that if you made it impossible to allow for voluntary contracts with people who have differential wealth, it would be an enormous impediment against the ability of people of unfortunate or limited means to rise up. His opinion as an analysis of this in a case called Adair v. Kansas is a model opinion on this stuff. When it came to water rights, he was the only Supreme Court justice who understood the connection between water rights as a private law matter and water law rights as a government matter. And he did this in a case called Kress. Now, why is this important? Well, what he said was the following arrangement. If you look at the way in which water is organized along a river, there are very powerful rules which indicate the limits that somebody could dam up water at the bottom of a river so as to destroy a mill at the top of a river. And when you teach water laws, I'm doing right now, these rules are very accurately done. Pitney understands them. And he says the federal government can't just pretend that these rights don't exist. Justice Jackson, the guy who wrote Wicked against Philbin, bad opinion, great justice, wrote a case called Willow River. And what he says is, we don't know what property rights are. Just because you've lost something economically doesn't mean that you've been hurt. But what he doesn't do is he doesn't understand that there's a deep and powerful structure of water law, and he just wrecks it and gives the state complete discretion to define property rights as it would. Pitney would never do that because he had been an equity judge in New Jersey, actually knew something about water law, unlike Justice Jackson. Now, the water law stuff doesn't stay water law. It gets you to Penn Central, one of the worst decisions ever. Because now we don't know what property rights mean in land. So we don't know about air rights. We don't know about mineral rights. Gets everything messed up on that system. So he does those kinds of things. He was a whiz on intellectual property. His INS case, which I'm actually going to be teaching tomorrow in one of my classes, he outperforms, outduels Oliver Wendell Holmes and Louis Brandeis. He's just smarter than they are in terms of the way in which this thing goes. He only served for 10 years, but he had a very clear conception of the role of government, which was born of a deep experience as a state law judge with an uncommon theoretical head. And it wasn't that he was a reactionary. He was anything far from that. This was the same justice, for example, who upheld the constitutionality of the workmen's compensation law in a case called New York Central Railroad against White. So the man got the right balance. He made mistakes on some technical questions. But unlike Brandeis, who could just go off the reservation and get things completely whacked up, and Holmes, who was amazingly good at certain things like antitrust law, not widely appreciated or understood today, but was much too skeptical on various forms of regulation and so forth. Pitney was a guy who did not suffer from those errors. Now, as I said, this is not a conventional choice, but then again, this is not a conventional book.
All right, we need a Pitney exhibit, although I need to put in a word on behalf of my hero, Justice Brandeis. Here at the Constitution Center, when we have a hard question, we ask WWBD, what would Brandeis do? I need to ask, on the current court, very quickly, I think you say in the book your favorite justice is Justice Thomas.
No, I don't have favorite judges, I think is what I said. Look, I mean, you have to understand, one of the first rules of being a successful academic, I think, is to have no friends. And I've managed to achieve that result in writing this particular book, at least amongst current justices, with a sort of wild situation. What it is I agree with particular opinions of particular justices, but it don't line up very powerfully with respect to the way in which the judges themselves decide politically. So, for example, in the chapter where I take on Justice Scalia for what I think is a misreading of the Second Amendment, because he gets rid of the first 14 words, a well-regulated militia being necessary for the security of a free state, that doesn't exist anymore. Well, I happen to know something about the militia cause because I worked for the National Guard many years ago and actually understood. It doesn't disappear. But the second terrible opinion, which I talk about, is one by Justice Elena Kagan, my former colleague, on cruel and unusual punishments, where she gets rid of the S and now has this wildly judicial interventionist stuff that we fear. Well, you look at cruel and unusual punishment without the S, and now it turns out you can't punish with life imprisonment this crime, with death that crime, and so forth. That is the worst kind of intervention you have, and the text doesn't support it. The S on punishments is a prohibition against certain kinds of torture. It is not a relationship between the punishment on the one hand and the crime on the other. And you know that it makes a difference because when they quote the darn clause, they drop the S off most of the time, and they're interpreting a clause which isn't there. So I regard myself as a bipartisan scourge. I mean, there's...
You're welcome to the National Constitution Center.
Yeah, I mean, because you can't let yourself be aligned with a political party. And the reason we call this a third way is because you spend an equal amount of time attacking both of these guys, both sides.
I want to get through a few more questions, but Ted, I'm curious, your favorite justice?
Pitney?
No, well, Penny was at the tip of my tongue.
Yeah, it must be Pitney.
I'll be very unlike Richard, very conventional, and my favorite justice is John Marshall.
Oh, that's good enough.
That's good.
And,
That's good.
and then I clerked, my favorite current justice, I have to say, had the chance to clerk for is Justice Breyer.
Beautiful.
Now, John, I would put down John Marshall because he did more than Pitney, obviously. He was there for a longer time. And he was a great judge, but he was also sometimes a fast stepper. Mm-hmm. And I don't like fast stepping. But my favorite opinion by Chief Justice Marshall is actually Gibbons and Ogden, which sets out, I think, a perfectly comprehensive view of the Commerce Clause, which has been mauled into non-recognition by people. I mean, to give you an idea of how bad it goes, when people, this is what I don't like about judicial interpretation, they can't quote full sentences. And so they change the word. So just to give you one illustration in Gibbons and Ogden, Chief Justice Marshall says, comprehensive is the word commerce is. It is restricted to that commerce which involves more state than one. And by the time it's done, the first clause disappears, and we are told that commerce now extends to those things which involve more states than one or infect more states than one. The word restricted is just simply removed from the quote. Now, why is this important? He was writing in 1824. And if you had changed the war, it meant that the federal government could have abolished slavery. Now, I'm all in favor of that as a principled matter. But the entire Constitutional Convention essentially had to have a compromise over slavery. And one of the pieces of that was limited federal jurisdiction. I think you agree with this, right? In terms of how they did it. And the irony is when slavery is gone and then you have that structure remains, now it's really powerful. Because what it does is it gets local state regulation over local matters, having competition across states, and it lets the federal government keep the network industries alive against state balkanization, which is the right constitutional structure in 1787 and the right one in 2014.
A few more questions. What is your view of Citizens United based on your constitutional vision?
Citizens United. This is, in my view, a very easy case. Scalia's opinion here, I think, is quite strong. And let me see if I can state the way in which this thing starts. Congress shall make no law abridging the freedom of speech. This is actually a federal regulation. And it's a perfectly general type proposition under these circumstances. And it doesn't identify who are the speakers. So the question then is, corporations are said to be artificial beings, and so therefore they can be subject to regulation. But there are two very powerful things that you have to remember. One is that the creation of a corporation is done by the state, and it's not done by the federal government. So the question now is, why is it that the federal government could regulate corporate speech in a particular way when it's the states that have the power over incorporation? The second thing that one has to do is a doctrine known as unconstitutional conditions, which says the federal government may or may not do something, but it cannot condition it on certain kinds of activities. So the federal government cannot say, yes, you're entitled to use federal highways, but you have to waive your Fourth Amendment rights against unreasonable searches and seizures. Essentially, any time the state has a monopoly power, there's a quid pro quo under classical liberal theory as to the conditions it can impose. And I wrote a book called Bargain with the State, which in nauseating detail went through all of these kinds of permutations. And asking people to suppress their right to speak because they have limited liability against contract and tort claims is crazy. A condition that is perfectly acceptable is one which says, we're not holding you responsible in torts beyond your assets, but we're going to require you to get insurance if you want to run this nuclear power plant and so forth. That would be an illustration on the other side. And then the third point to make is that this is just a question of whether or not you could stop pre-election speaking within 30 days of an election or 90 days, depending on what it is. This is core political speech as far as I'm concerned. And the idea that somehow or other you can block that because corporations do bad things, it's crazy. Citizens United isn't a real corporation. There's a political operation, Citizens United. They don't make anything. They wanted to put out the film called Hillary the Movie. The idea that a partnership could put that out without restrictions and a corporation can't is crazy. Now, real corporations, their view is they run for cover. I've worked with these guys. First thing they do when they see Citizens United is, please, we're taking a vow of silence because we don't want to have to speak out for gay rights, against gay rights, for pollution, against pollution. We're trying to sell beer. Right? And the guy, for example, who ran Whole Foods, who's something of a libertarian, who campaigned one day against Obamacare, found himself with a massive boycott on his hands within 48 hours. These guys are timid. People who have to sell into consumer markets are the most pusillanimous people on the face of the globe when it comes to taking political statements. And so it's a non-problem that you're worried about. Bribery, other kinds of stuff is already regulated by existing laws that nobody does. I think this is just wildly overstated in terms of a serious issue. And I have to say that the Justice Stevens opinion, right? I admired his dissent, great dissent in Heller, right? I thought his dissent in this case was dreadful beyond words.
A response, Ted, on Citizens United, and then we're going to
I think, you know, I could, if we've got more questions, let's...
Okay, I'm going to give one more question, and then we're going to close. Let's keep this, the question asks, well, here it is. Were the country to recognize the need for a classical liberal constitution, yet also want to keep most of the current federal government, how would you frame an amendment to accomplish that end? So just give us the amendment. It's a great question.
Yeah.
Yeah, but you want to sort of basically lock in all existing institutions but not go further?
You vote against it, but what would you read? What would just draft it? What would it say?
I don't even know what I'm supposed to achieve, so it's very difficult. If I want to draft the classical liberal constitution, I mean, the question is how it is that I would do this today. I would have an amendment in several parts. And what I would try to do is to pick the 3 or 4 things that I think are the biggest weaknesses in this area and say they don't do it. So I'd have a clause which says commerce shall not include manufacture, agriculture, mining, and so forth. And I would say that property includes the protection of not only the exclusive rights, but the right to use, dispose, and so forth within the limits of the common law. I would introduce a doctrine of unconstitutional conditions, which says the government may condition various exercises of constitutional rights only on those things which, if they occur, they could block under the definition of the police power, which appears in the 4th section, which essentially leads it to the 3 things that I talked about before, which is nuisance on the one hand, fraud, various kinds of situations, and monopoly. And if you put all those things into place, I would not grandfather existing institutions. That would do it. I mean, the point to understand about this is it's a long book, but the reason the book is long is not because the theory that I want to have is beyond the capability of expression in a short compass. It's because the number of mistakes, in my judgment, that have been made over 200 years, you have to do it. It's not credible, I made the decision, to write a long book in which I said, here's what I think is right, without explaining why I think all this other stuff is wrong. And so it's not an impossible thing to do. You've got to get somebody who's willing to do it. I regard Ted, in the sort of general distribution of people, as being wildly more sympathetic to my general views than the median person out there in the political or constitutional space, which gives you some idea as to where it is I'm sitting out there.
Well, on that score, so Richard refused to draft the pro-federal government amendment and drafted the classical liberal amendment. What would the pro-federal government amendment look like? Congress has the power to regulate interstate commerce and everything else?
Well, we could play with words, and I think we could accomplish a lot just by expanding the Commerce Clause to incorporate something like the aggregation principle, that if you engage in activity that affects interstate commerce, Congress can regulate it, which is another way but of course that is the Supreme Court case law, which is another way of saying and responding to this question is that the constitutional order that we live in today, I think, reflects this duality between wanting the government to do some things and also wanting to protect the liberties that Richard is talking about. So I've suggested that even the framers, Madison and Hamilton, certainly wrote about this. They felt that differential pull. You want a government that has force and vigor, but you also want to protect liberties. And I think in a sense, that is the Constitution we have, so that Richard's vision is unusually pure, whereas I think the actual constitutional realities and our civic values, which are reflected in the Constitution, are much more binary and reflect this push and pull between active government and then protection of liberty.
Can I comment on the liberty point?
Briefly, and then we're going to give you some very strong applause.
Oh, well, no, I'd rather talk than be applauded. I mean, there's been a complete reversal of the polarity with respect to liberty between the 19th century and the 21st century. And it is, I think, bears of this. When I read off those things under the police power, there were 4 headings. I concentrated on health and safety. I didn't spend much about general welfare, but that meant classic public goods, which for the layman in the audience means a good which is non-exclusive. You can't give protection to some American citizens unless you give it to all, and therefore you have to tax them, otherwise it will be underprovided. But there's this funny word called morals that's in there. Now, the morals head of the police power is, by, I think, common acclaim, the least libertarian portion of the classical Constitution, not the classical liberal Constitution. So what could you regulate in the 19th century under the police power? Well, you could regulate bowling, for example, because it tended to lead to sinful activities.
Obviously.
You certainly could regulate any form of gambling that you wanted. You could regulate anything associated with sexual behavior, inside or outside of marriage. You could criminalize sodomy, you could criminalize homosexual behavior, you could criminalize adultery, you can criminalize fornication, you can impose all sorts of minimum restrictions on what ages you could marry, the degrees of marriage, and so forth. This was soup to nuts regulation, and the basic 19th century view of the world was not consistently libertarian. It was freedom in the economic sphere and powerful regulation in the moral sphere, which sort of carried forth much of the puritanical tradition that had existed early on. You come to the 20th century, all the economic liberties disappear in the wake of the Lochner decision through the New Deal. So, I mean, and it's joyously struck down. We can now have labor unions, we can have maximum hour laws, we can have minimum wage laws, we can have overtime statutes, we can have union statutes, we can have anti-discrimination laws in labor markets. Hallelujah. Then comes a case called Griswold against Connecticut. And all of a sudden, it's unconstitutional to ban the sale of contraceptives in the good state of Connecticut. And Justice Douglas, who writes this opinion, is a tap dancer. And what he says is, well, I look at all the penumbras of the Bill of Rights, and I see this prohibition just about everywhere. And so all of a sudden, everybody's worried about, hey, where are you getting this? You believed in judicial restraint and not. And it's clear it's the opening gun in an area in which now the liberty side is done with respect to sexual relationships. So he says it, and he writes it, and he insists that, oh, this is just for married people, not after Eisenstadt and Baer, 1972. It turns out it's an individual right. It has nothing whatsoever to do with marriage. All sorts of college kids over the age of 18 may enjoy whatever contraceptive benefits they want. And then a year later, you get Roe v. Wade. And then as you keep moving forward, you get the prohibitions on sodomy laws. First, what you do is you decriminalize this stuff. Lawrence v. Texas, 2003. And now, I mean, the push towards the legalization of gay marriage is so inexorable that it surely will take place, maybe by legislation or by constitutional law within the next 5 years. The opponents of this are in complete disarray. And so liberty in this area is high. And what's so ironic about it is the guys who are in favor of all of these changes, they don't have any questions about courts micromanaging the overall system. My view is I'm torn for a different reason from Ted. As an originalist, meaning somebody who takes it seriously and is willing to allow for the prescriptive constitution for things done past, I know that every one of these decisions, like Roe v. Wade and all the gay rights decisions, are wrong. But as a libertarian, I don't want them. I mean, I do it. So do I do it politically? Do I stand aside? I'm just genuinely torn on how to go. But it's clear to me that I think in the end, intellectually, the economic liberties are more important to protect than the other liberties, because those are going to be protected, oddly enough, through the political process today. They weren't protected 50 years ago, but you couldn't get the courts to protect them at those particular times anyhow. But it's the dichotomy that is so striking. And if I had to end with the following plea, It's a uniform theory of constitutional interpretation that starts with how you put this government together, figures out its structures, figures out the federalism. We didn't stress separation of powers, but that would be part of the picture. Gets the individual rights. You need a soup to nuts theory. And history intrudes on this morals head of the police power. And if the price for getting a comprehensive theory is to abandon fidelity to a set of decisions I don't much like anyhow, I'm willing to do it.
Ladies and gentlemen, please join me in thanking Richard Epstein and Ted Rosen.